Welcome to Health Law Talk, presented by Shahardy Sherman Williams. Health law broken down through expert discussion, real client issues, and real-life experiences. Breaking barriers to understanding complex healthcare issues is our job.
And good morning or good afternoon, everyone, wherever you are, whatever time you're listening. Another episode of Health Law Talks at Shahardy Sherman Williams. And just as the title suggests, today we're going to be talking about basics of a healthcare law analysis. Sort of like what happens when providers call healthcare lawyers and say, oh, I want to buy this or I want to do this deal. What do I need to do? How do I need to structure it? And in the suite today, or the studio today, again, our co-host, Rory Bellina.
Good morning or afternoon, everyone.
And Rory and I thought today would go sort of a throwback back to basics. I know that we've talked before on some very advanced topics, but a lot of times we get calls from physicians just starting out in their practice, or they're very entrepreneurial and they want to sort of take over the world, and they say, I want to buy this, or I want to go into this deal. And suddenly, you get the call. And so we wanted to talk about what goes on in our minds. And how do we help clients out when they first call us on some of the basics of a structure analysis?
Sure. So I think what we talked about, and I know we discussed this in a previous episode, is getting past, what you want to buy and talking about your purchase price, and are we going to do a non-disclosure and go into that little exclusive period. And we've talked about that before, and how to structure those, kind of the art of the deal episode that we did. But moving past that, once you kind of get past that and decide that it's something that you can financially do and something that you're very interested in, we start to look at it from a healthcare side. And there's definitely an initial analysis and then a more detailed one. And typically we get a lot of questions, or ask a lot of questions in the beginning, and then kind of unpeel the onion and see where we need to go after that. And is this something that you can do, that the client's going to be happy with, if we have to put parameters on it, and what it would look like?
So the first, I guess, and when we talk about deals, and I know we did do the art of the deal. I mean, I remember that episode; that was really good. But a deal could look like anything from a physician wanting to buy another practice, a physician wanting to buy some sort of an ancillary service like an imaging center, or physical therapy, speech therapy, anything that could be considered ancillary, maybe even DME, right?
Sure.
Or something like that. So when we first get the call, even sometimes before the LOI or the NDA, before we even get to those things like the art of the deal, I know sometimes it's after, the question becomes can I do this? Sure. Right? So the first the first thing that triggers, I think, in the healthcare lawyer's mind is this a Stark issue? Sure. Or an Anti-Kickback issue? I mean, the two basic regulatory schemes that we think of structure-wise, because those are the two things that would affect, I think, the deal the most.
Sure. And I think a lot of times, our clients, I noticed this is definitely true for me, they get pitched before they call us.
Oh,
they're at a dinner, or they have a friend that's doing this. The friend one is the one that always gets us, not in trouble, but we sometimes have to rein that in, because they've got a friend that's doing it or has been doing it, and now they want to do it. They see how lucrative it is.
All these other people do it in this state. Why can't we do it?
And then sometimes we have to say, well, here's why we wouldn't advise that, and let's go into those details. But a lot of times they've already been pitched on it. They're excited. They see their buddy doing it, how profitable it could be, how it's changed their business, it's made their life better. And, they want to do this ancillary company or whatever it may be. And that's when we have to say, okay, well, what is this going to look like, and what all does it entail? And like you said, is this a Stark analysis? Is this going to be an anti-kickback analysis? And the big thing that we have to that I jump into my head is, okay, well, what is it? What are we billing? Who are the patients? Who are the payers? And I think that is where you and I both typically go to first, is what are we billing? Is this something that, based on the code, is it a designated health service that is going to put us in the Stark world, or is it not? And can we just kind of push that analysis off to the side?
Well, let's step back for the listeners. So for those of you who are not familiar with Stark, this is I guess what we call a mosaic fluid regulation that has evolved over decades
Sure.
in the healthcare world that was initially, legislated into law through Pete Stark.
Sure.
I mean, way back when, I would say, was it the 80s?
70s, late 70s or 80s, I think.
And so the initial thought was that we wanted to curb physician overutilization on Medicare services through some sort of a scheme to make money, by shuffling patients to ancillaries that they had, overutilization problems, right?
Their families was the big concern at that time, and
Right.
and it was apparently very prevalent in California, which is where Pete Stark was out of.
So basically, the Stark law can be broken down into, they call it the self-referral law.
Sure.
And so a physician provider, and that's a defined term, a provider is prohibited from referring patients to an entity within which they or an immediate family member have an ownership interest for designated health services unless a specific exception applies. That is the 50,000-foot view of the rule, right?
And every word you just said is defined.
That's right.
Is defined in the law very specifically, and there's been revisions to it, and Stark 2, changes some things, and there's been. We're not going to get into that today. We'll stick with the physician example, but I just like to give our listeners a little commentary or color on that. It defines what a physician is. It defines what is your cousin an immediate family, well, is your second cousin, your cousin by adoption. I mean, it goes into all those details. We're not going to do that.
What's a referral, right?
Sure. What's a referral? That's a really good one. Designated health services is probably the cleanest thing because every year
there's a list.
CMS puts out a nice spreadsheet. And you can just, if the doctor tells you the CPT code, you can just search and say, yep, it is, or nope, it's not, and kind of move on from there.
So one of the things, as Rory was, we were discussing, when we think about the call that we get and say, okay, who is our patients, where are they coming from, et cetera, in our minds, we're going through this Stark analysis, So in our minds, even though we're not going to go into the detail of the defined terms, I'm thinking, okay, where are the referrals coming from? From what payor? Is it Medicare, which would clearly apply with Stark if, again, the other things applied?
Sure.
Is it commercial pay? Is it anything that's going to affect our state law here in Louisiana? And so you're running through those rabbit traps. So break down, from the Stark problem analysis. Number one, is it a referral, right? Number two, by a physician or provider to an entity. What's an entity? Within which the provider or an immediate family member, which is also defined, has an interest, right?
Which is defined.
Which is defined for DHS. Okay,
Yes.
And if it is, it's prohibited unless an exception.
Correct.
Now, here's the funny thing: how many times have you seen on a piece of paper an attorney write, "Oh, this is a safe harbor. What's the safe harbor versus exception?" How many times have you seen them interchange those?
And those terms, you get the safe harbors from AKS move over to exceptions to Stark and vice versa, and we'll get into that. It's just because you think that you're meeting a safe harbor doesn't necessarily mean that it's.
But then again, I have to question. I mean,
Sure.
Does the lawyer on the other side really know what they're doing when they make that? Right?
When I see those terms interchanged, it's either done in a commentary like this where you're just talking really fast and you just switch the terms, but sometimes you can pick up little cues that, okay, wherever they got this advice from, they used the wrong term. Let me take another look at this.
Right. So back to Stark. So we do our Stark problem analysis and kind of say, okay, all right, do we fill these buckets, right?
Sure.
And that's the first sort of I guess hurdles, right?
Sure.
That you swim through.
Yeah.
And then the lawyer will kick in and tell the doctor, okay, well, or provider, this looks okay, and we can move forward if we structure it X, Y, Z. And then, or that's an opportunity to say, well, no, this is not going to work.
Yeah, and you could stop right there.
What would go on next in your mind if, from the regulatory perspective, if a deal or structure was coming after you've sort of run the rabbit traps for Stark?
So I think that the big thing with Stark is that different from AKS is that it's civil and not criminal.
That's true. We could talk about that. What's the difference, right?
And a big thing is that it's not intent based. So a Stark violation is a Stark violation, and it is or it isn't. And so there's not as much gray area with AKS. A lot of people are much more comfortable when they get out of the Stark world because they know, okay, I don't have to worry about that. If there's an alleged anti-kickback violation, they've got to
But what you mean by that, though, you mean like, in other words, it is or it isn't, mean like you have to comply with all of the points of the exception or you don't get it.
Correct. You comply with it or you're in violation unless you fit in a nice little box of an exception. And there's not a whole lot of gray area with Stark. No. That's how I like to look at it. And I think it's guided me well. It's guided our clients well. There's a lot more movement and nuance on the anti-kickback side.
How many times have you had to have a provider tell you on the phone, Rory, you don't know the Stark exceptions by heart? Shouldn't you tell me the answer the moment I tell you my hypo?
You know, that I do get some phone calls, and sometimes you're in the car and you're driving and you get that question and you're like, hold on, I need to really think this through, because it's a complicated analysis, and it's a yes or a no, and so you don't want to give that advice. There's really no gray area in Stark, and so you really want to make sure that you're getting it right and looking at it and making sure that they do fit within an exception, because if they don't, it's strict liability. It's a violation's a violation. There's no, I didn't mean to do that. It's there.
Well, one interesting thing about that, and sometimes I use this example. I said, well, doctor, you're calling me on a phone call, giving me your hypo or your structure of your deal that you want, and you're asking me to give you an answer today. Let me ask you this, doctor. If I came in your office and said, doctor, I'm going to tell you how I feel, and I'm going to tell you that I'm not feeling too well, I'm sick. I don't want you to do any diagnostic test on me, but I want you to tell me what's wrong with me. What would you do? How would you respond?
No x-rays, no lab
x-rays,
work.
no lab, no CTs, no MRIs, no nothing. And doctor, I want you to diagnose me right now.
And if you don't know what it is, I'm going to call the next doctor.
The funny thing is, when I say that hypo and I kind of shoot it back at them, putting it in their court, they're like, oh, I get it.
That makes sense.
Right, it makes sense.
That makes sense.
Right. You know, and so that example has worked for me 100%.
That's a really good one. I'm going to start using that.
You should, yeah.
Because a lot of times I will get the call and you have that moment of pause and hesitancy of, okay, I think I know the answer in the analysis, but I need to sit down and sketch this out.
Yes.
Draw out the relationship, double check everything.
You're not copyrighted that.
That's a good phrase.
I give you an unrestricted free use of that copyright.
There you Everyone go. Listening heard that. So thank you. Thank you. But assuming that an easy one that we can use as our example today is physician investment in an ASC. I think that's probably one of the most common things out there. You got a lot of doctors out there. You got a lot of doctors that do procedures.
Well, because now that the whole hospital exception's gone,
sure,
the next avenue is getting something on a facility fee, and the ASC is the target.
Sure, and I think ASCs are having relatively shorter and shorter lifespans from what I see.
Yes.
They're opening up, they're lasting a while, people are making their money, and they're closing or being sold. And then we're going to open up a new one with new technology and new equipment. And so you keep seeing this cycle of physician investment. So I think that's a good example that, gets you out of Stark. We don't have to worry about that. Pivot over to the AKS side.
Well, and I think when we get to AKS, it's a lot more difficult.
Sure.
Because now we're looking at a criminal-based, intent-based, regulation.
Sure.
So now when I try to tell providers that AKS is more problematic, the issue with AKS is that the safe harbors are there that I find you're never going to fit one wholly 100%.
Correct. And another thing that's very nuanced with the anti-kickback statute, which you give a really good definition for Stark, so I'd love for you to give one for AKS.
Okay.
Is that just because you don't meet a safe harbor doesn't mean that you're violating AKS. You want to find one for your client to be in, but just because it's not there doesn't mean that you're violating it. So, but before we go there, AKS, differentiate that or tell everybody what that is compared to Stark.
So AKS is this for anti-kickback statute, and basically it was a regulation that was put into place by the government, not necessarily for just healthcare, but really for anything.
Sure.
So basically, it prohibits any remuneration And that
Which
could
is
be
defined.
Again, defined term, and that could be in cash or in kind, and that could be in anything.
Yep.
To basically elicit overutilization of governmental services, if you will. And that's the broadest the broadest definition. I mean, I'm sure there's a lot more defined definition in the statute, but that's how I see it. And maybe did I hit all the points? I don't know if I hit them.
Those are the big points. Where my analysis almost instantly goes, or really when people call me and ask me for, is this a violation of AKS? They'll say, but we're going to carve out Medicare patients. We're not going to do. We're not going to do Medicare patients. We're not going to take TRICARE. We're not going to do Medicaid patients. Does that change your analysis? Or what about in Louisiana? Does Louisiana have a mini AKS?
They do.
Or state? And
we do.
And uniquely in Louisiana is that it's payer neutral.
It's payer neutral, and in the state law we do. So you could cut out Medicare, and you could cut out Medicaid, and you could cut out TRICARE, you could cut out FEBA, everything out from the feds, right? But in Louisiana, our state, we have the mirror, I call mirror AKS.
Sure.
So if you want our state attorney general looking at you,
right?
You could continue that route.
Which, to my knowledge, I don't think has ever been prosecuted.
I don't think so either.
But you don't want to be the first one either,
right? The test case,
especially when you have an aggressive attorney general. So I don't think anyone wants to get on.
I think we could say Jeff Landry is very aggressive.
Yes, I don't think anyone wants to get on his radar, especially for a healthcare thing in this political climate. So
no, I agree. I totally agree.
But getting into we move past that in our comments with the client and talking about go back to my doctor that wants to invest in an ASC.
Okay.
We're not in Stark because it doesn't meet a code that's designated health services.
So Stark. So when it's probably the easiest time to say it's not Stark. If it's not on the enumerated list of DHS, it's out.
It's out of my head.
We're done.
Or I'm out.
Totally done.
But now I'm thinking of anti-kickback,
right.
And I'm thinking, is there a safe harbor for this? How do we structure this? And luckily, there's safe harbors out there for a majority of things. I would say there's not a whole lot out there that's just a hard no. What are some things that you've run into that you think are I guess, a hard no on something?
Recently, that's a good question. Recently, I've had a question about physician-owned distributorships.
Okay, pods.
Okay, and the question was by a neurosurgeon. If I develop X device, with X company, and I own a portion of that company,
right?
Okay, can I then have my hospital, which in this particular case, it's one of the few private hospitals left. Okay, can I require my hospital to buy from this
pod?
Right. So, and this hospital is Medicare.
Okay.
So in other words, they got in right under the gun before ACA. It's Medicare approved, and says, well, can I require the hospital to buy from the pod my device to use in my patients? And the answer to me, is pretty clearly no. That's a direct line. You're benefiting from the purchase directly, and you're in the position to refer. That's a prohibited remuneration unless we can find a safe harbor that would apply.
Right.
And I don't think there is something that, with that direct, straight line like that, something that would apply.
Yep.
So that would be the hard no.
What are your thoughts? I know that another popular one that I'll always get is when you've got someone who wants to bring in a rep, and they use that word very loosely, but a rep.
Like a sales rep.
A sales rep to market, another word that I use very loosely, a sales rep to market something. How are you going to structure that, and what are the pitfalls that they're going to face? Because 99% of the phone calls that I get, when someone wants to bring on a sales rep to market a medical device, they want to pay them on commissions.
Right.
They want to pay them on doctors that get signed up.
That's the first thing I ask is, how are you paying the sales commission?
And tell me the truth.
Right. Because I can't give you advice if you tell me one thing and then do another, because it's not going to work.
Right.
So if you're paying the sales rep based on volume or the value of the sale, we have a problem.
Absolutely.
That's just, that's it. If you're paying the salesman a set fee right? In other words, your annual salary is X, regardless of the volume or the value of the sales.
And we set it for a year.
Which falls under the bona fide employment safe harbor. I'm okay.
Yep.
So here's I'm going to lob it back in your court, Mr. Bellina. So what happens if the response to the question is, okay, in this particular case, a sales rep, what happens when we set out a bona fide safe harbor through exactly what we talked about, 1 year set in advance, but I've got a bonus structure. I have a bonus structure because I want to make sure to bonus all my salespeople.
Right.
Got to bonus them, right? That basically pays on a not per sale, but a bracket. A bracket. In other words, if you've got 150 sales, it's 5,000. If you got whatever the number is, it's 10,000. Sure. It's a lockstep.
Because now you're paying him, you're bonusing him based on the volume, essentially, or the value that he's selling.
But I'm arguing that no, it's not really volume because it is a block, and then the block is set in advance. So, see, this is where the fun begins. This is the gray area, right? So,
and this is where intent comes in too.
Correct. So, if the intent was to reimburse the salesman, or compensate the salesman based on the volume, which I would argue it is. I would say anytime you're giving a bonus based on the number of sales, even if it's in a block, even if it's set in advance, even if the amounts are set in advance, you're still compensating the sales rep on a volume of sales. Though I see the counter argument to that. So
the counter argument is that they might not sell anything, and they're still going to get that base. You've set it in advance.
Yes.
It's been set for a year.
What about setting the block in advance? So in other words, the block bonus of like 5,000 is set in a year. It wasn't saying, oh, you did 100 sales. I'm going to give you 50 grand, whatever, whatever it is. It's set. It's already set, but it's set based on volume.
From what I've seen, again, like you said, that's a very gray area.
How often do we get gray area calls?
It's very common, and is the government, is the OIG looking at that,
right?
And what's been their advisory opinions on those type of relationships?
That's another good thing to talk about too, because just as we both know, OIG posts advisory opinions on their website, which also provides good guidance on how the government views certain structured arrangements.
Sure, and I think it's important to always look at those. It's important to know that the advisory opinions are just that. They're advisory. They redact 50% of the information out of it, and they always say that it's fact-specific and situation-specific, but it gives us a little bit of a look inside the glass of how the OIG is looking at these things. Right. Are they doing... I think the big thing, from what I can tell, is what they're looking at are really like the sham employment agreements, and I think you get into trouble where your base salary is so low and the bonus is so high that it really is a sham pay for business.
But an example like that, I mean, when you talk to clients and you talk to and they want answers, right? How many times have you told a provider or client that, look, I see your compensation model, I can't guarantee you nothing's going to happen.
Right. It's common. You can't, because again, it's intent based. It's if the government were to come in and say you were intending to defraud and intending to induce compensation or remuneration.
So let me ask you this. So what advice would you give not only healthcare lawyers, but providers who are seeking to do, in this particular case,
model?
Right. I mean, how would you advise them? What recommendations would you give?
I think in the model that we're talking about, where there's a set base and then it's compensation, is that it needs to really look and smell and feel like a true employment agreement. And look, a lot of people do bonuses and different types of programs for selling more, but it needs to have some structures of a true employment agreement. There needs to be, and it goes back to kind of the argument of, are you really an employee? Or is this a sham employment agreement?
Right.
And you're really an independent contractor,
right?
And you never go into the office. You never get any training. You never even talk to anyone. You just go out and sell. They're giving you this little $10,000 base salary, and then they're just bonusing you 6 figures, and you've never been into the office, you don't do anything, you've got no set hours, no oversight, no nothing. I think that's a pretty clear argument. It's a sham employment agreement. You're being paid based on your volume and value. That's the kind of thing I advise against. I think that you look at the factors of what is a true employment agreement. Are there parameters in place? Are you checking in with that rep? Are they being accountable, or are there meetings, some sort of set structure and hours and schedule where you know what they're doing? And is their compensation realistic for what they're doing? And then they really do get a bonus on top for going over and above. It's hard to draw that line because the owner of the company wants to give them as low a base as possible. He wants it to be all production based because the more money he makes, the more he obviously doesn't care about paying out. And the reps are very used to that too, because just because it's not the right way to do it, for every 10 calls I get where I give that advice, there's another 50 people out there that are doing it the wrong way. And all these guys talk. All these reps talk, and they hop around from one place to another. And before this was so heavily regulated, especially in like the device world, that's how all these guys get paid.
No, and true. I mean, and we're talking about one single safe harbor here, the bona fide employment safe harbor. So, I mean, there are many more safe harbors that we could discuss. But,
sure.
But and just like Stark Law exceptions, there are tons of Stark Law exceptions. We'd only touched on I think one, and we can So when we're looking at this, you're looking at as many safe harbors or exceptions as you can, and in this particular case, I mean, clearly, especially when you come to AKS, there isn't a 100% guarantee like we're Stark. If you don't meet everything, you don't get it. And
I think it's important before we wrap this up, because I know we got specific on one safe harbor, is explaining to the client what it is. It's a criminal statute and it's intent based.
AKS.
Yes. So really explain to them that, look, if there were to be an allegation, the government would have to allege that you intended to defraud and prove it, and they have to meet that burden. Now, it doesn't make clients feel very comfortable because you want to get them in a safe harbor, but it's a lot higher of a burden. And so, can they meet it? Has the government met it? Yeah, they do it all the time. They'll get you under a grand jury indictment, and they've got all this evidence. They go through your billing records. They dive in your trash can, or there's a whistleblower that's telling you, these reps never come in, and they get this little check in the mail and they get their huge bonus at the end of the month. And that happens all the time. And has the government proven it? Yes, absolutely. Or they'll get you to crush under pressure, or get somebody to flip on you and take a deal. Yes, because they want that win, they want the money back, all that. But it's still important to advise that it's intent based, and I think that gives clients some comfort, because a lot of clients have no intent to defraud. They just want to structure it the best way that they can.
And I know we're wrapping it up, but I do want to say this. So when you do the deal, and like we do the art of the deal, and you write in there a paragraph, and you know I'm going with this maybe, that we have no intent of violating the AKS.
Sure.
And you put it in writing. So, and sometimes I have clients say, well, if we just put it in writing, will that satisfy it? I mean, I try to tell people that just because you write it down.
Well, if I'm ever requested to give a written opinion on an anti-kickback statute, I'm very cautious with what I write, and I'm very clear to say this is a criminal statute that is intent based. It's because you just don't know, but you have to.
Just because you write it down doesn't mean
correct.
You're not trying to violate it, right?
Correct. So those are the big things, and like the big analysis that we have to go through to make sure that deals are structured the right way. And I think our plan for future episodes is to get to talk more about Stark, how it started, how it's evolved, how I don't even think it's really shifted. And I think I believe he's no longer alive, but I believe he made a comment that he didn't like it the way it is now. Didn't Pete Stark make some sort of comment about how he did not like the way it's evolved, and if he could go back in time, he would undo it?
Well, interestingly, I think there was some comments to that effect. My question is, and we could talk about this in another episode.
Sure.
Because this could
a policy topic.
A policy topic. In other words, now that we're moving to value-based reimbursement by Medicare, right, which is paid per episode of care, is that the death of Stark? I mean, Stark was meant to prevent overutilization. So if you're paying on an episode of Care, no longer fee for service,
right?
Do we really need Stark?
Right, and you've got all these quality metrics.
Or any kickback for that matter. I mean, do you really need any kickback in the healthcare world if it's a pay per episode of Care?
Yeah, that's true.
Just curious, So but I agree with you. I think in future episodes, these sort of back to the basics, analyzing. I mean, I thought one good idea would be analyzing like the group practice.
Yep.
What's the group practice exception, and how does it? What is a group practice?
Yeah. So please comment if there's something specific that you want us to talk about in the Stark or anti-kickback world. Today we got a little bit deep on the employment exception or safe harbor. See, I used the wrong phrase too.
You just did.
I did it too. If there's a specific one that you want us to talk about, or if you've got a deal in mind, I mean, you could obviously comment and say, don't give us all the information, and we could do a little analysis on the show on how we would advise on it.
Yeah, I think when we say comment, if you want to send us an email on our podcast email, I think we have it. Was it podcast@shahardy.com?
Yes, it's on the link. It should be in the link below on the episode.
Yes, so you'll see it. Podcast@shahardy.com. Send us an email and tell us what you want to hear, and we can go ahead and try to make that happen.
But we're going to keep diving into AKS and Stark a little bit more and go from there.
Fantastic. Well, that'll wrap it up here. I think, Rory, good job on that. Excellent job, my friend.
Thank you.
And I want to say thank you to the audience again for listening to Shahardy Sherman-Williams on our Health Law podcast. We are going to wrap this up. Hope you have a great weekend and enjoy everything that you do in life. We'll see you next time for another episode of Health Law Talk with Shahardy Sherman-Williams.
Thanks for listening to this episode of Health Law Talk, presented by Shahardy Sherman-Williams. Please be sure to subscribe to our channel, make sure to give us that 5-star rating, and share with your friends. Shahardy Sherman-Williams is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does this podcast establish an attorney-client relationship. Reference to any specific product or entity does not count as an endorsement or recommendation by Shahardy Sherman-Williams. The views expressed by guests on the show are their own, and their appearance does not imply an endorsement of them or their entity that they represent. Remember, please consult an attorney for your specific legal issues.